Time the 2 million lawyers in India had an industry association, um, and a lot needs to be done. But I think for us to do everything we want to do, we need an association. So we started Indian Lawyers Association in 2018. There's a lot of small bar associations and lawyers associations throughout the country. The courts have, but nationwide, one organization for the entire profession we felt was needed. There's 400 cities in India, as you know, with a population over 1 lakh. So we want a chapter in all 400. We are in 100 cities now. We have a staff. We do weekly meetings, and each chapter runs independently, has their own board of 16. They're welcome to do anything they want, have their own membership dues, do any events they want. Um, it's a slow but steady progress. We've had wonderful sessions, and then once a year we do a live in-person nationwide conference. We've done in Pune and Mumbai and Delhi and Rohtak and Dubai and Hyderabad. So it's been well received. We have 50, 60 speakers that show up. So we've never done a panel on criminal law and thought it's time we did one. And this time we felt that we should have a judge and we should have somebody from the police. Otherwise, it's just lawyers. So thank you for joining us.
Thank you. Thank you for bringing us together. That's exactly what I said. Thank you for bringing us all together, all stakeholders in criminal justice system.
Thank you. So we'll start with introduction from the other panelists, and then I'll introduce you, Dr. Bedi. So we'll start with Judge Ranka. Tell us about your life and profession. Be muted.
Yeah, good morning, everyone.
Good
So wonderful to see you all this morning. And certainly all credits to Navneet Chugji for bringing us all together on this wonderful platform. And wonderful to see Honorable Madam Dr. Kiran Bedi ji, very, very renowned figure and certainly role model for many of us and majority of the females in and outside country. Other eminent panelists, I am Justice J.K. Ranka. Of course, was a lawyer, practiced in the Rajasthan High Court and Supreme Court for almost 25 years and then elevated to the bench of the Rajasthan High Court. And again, after retirement, I was designated as senior advocate by the Honorable Supreme Court. I am organizing a few moot court competitions, having tie-up with 6 universities in Jaipur, in Rajasthan and Haryana, and other law-centric activities go on with the young students or young lawyers. And of course, other similar activities go on, keep me busy in one or the other event like this also. So much to learn when a subject comes to you, irrespective of being a former judge or otherwise. So much to learn from you all, and reading is my passion. So I keep learning and unlearning. Yes.
Thank you, Judge Ranka, for joining us. Please come more often. Amy Mirajkar, tell us about your life.
Hello, good morning, everyone, and thank you for joining. My name is Amay Mirajkar, and I'm a partner with Khaitan and Company, a law firm in Mumbai and elsewhere. So I basically operate in the area of dispute resolution and white collar crime. I'm honored to be given this opportunity to share my views with this distinguished panel. Basically, I'm born and brought up in Mumbai, 2009 graduate, 15 years into this practice, and mainly dealing with white collar crimes, having worked in 4 different law firms, and till now handled around some 3 scams from NACL to DHFL
Recording in progress.
to Nirav Modi. Currently, we are handling the same, and I would like to share my views on this panel.
Thank you for joining, Amay. Dheeraj.
Good morning, everyone. My name is Dheeraj Nair. First of all, thank you so much, Mr. Chuk, for putting all this together. And indeed, a delight to be here and honored to be sharing a panel with Dr. Kiran Bedi and Justice Ranka and Mr. Pava here. Thank you so much. I am a lawyer for almost 2.5 decades now, of which I've spent 20 years of my life in a firm called JSA, where I'm a partner. I head their disputes practice, and I also dabble in white collar crimes, including white collar anti-corruption, anti-bribery, internal investigations, as well as anti-enforcement directorate matters. Have dealt with SFIOs and CBIs and local police authorities. So I wish to bring at least some kind of a corporate commercial white collar aspect into this discussion as and when we progress in the discussion. Thank you so much for having me here.
Thank you for joining, Dheeraj. Mr. Vikas Pava, tell us about your life.
Good morning, everyone. Thank you, Mr. Chok, for giving us the opportunity to be part of this very interesting topic. Although the topic is very, I would say, the way it is framed, it arouses, some kind of a feeling, even of a common man, whether we would be able to achieve it or not. Anyway, we'll discuss that later. I'm a senior advocate in the Supreme Court of India and also Delhi High Court. My primary practice is on the criminal side, and we do litigation, and we do massive litigation in the country, all over the country. We appear in the trial courts and till the Supreme Court. So we have a hands-on reaction to all the questions which you may have with regard to criminal justice system in our country. And it's a pleasure to be here. And whenever we start, I think we all are roaring to go. We would like to share our individual reactions to what is happening in our country nowadays. Thank you so much.
Wonderful. Thank you for joining. Ramandeep, your turn.
Hi, everyone. Good morning. Always great being part of such discussions. I practice in Delhi. I've been a first generation lawyer, and I've been, struggling my way few years. In 15 years in this profession, my main focus is criminal, and I do a lot of matrimonial cases in Delhi and pan India. And it would be great when I can give my insights on how and what I feel about the criminal, and especially this topic. That in 90 days, what difference can we make, or should we make a difference regarding total of cases? And with Mr. Vikas Pava sir, through the freedom of two times, it will be a great thing for me to follow and discuss and take this discussion. Take this discussion forward.
Thank you for joining, Ramandeep.
Yeah.
It's my pleasure to introduce the Honorable Dr. Kiran Bedi. As the entire country knows, she's India's first woman officer in the Indian Police Service, joining in 1972 and went on to become one of the highest ranking officers. 4 decades she has worked and contributed to public administration, innovative policing, and prison reform. She also served as the Lieutenant Governor of Puducherry. She's worked with the United Nations in New York as police advisor to the Secretary General in the Department of Peacekeeping. She's represented India at global forums on crime prevention, drug control, prison reform, and women's issues, and addressed audiences around the world. She's the founder of 2 NGOs, Navjyoti and India Vision Foundation, focus on educational, vocational training, counseling, healthcare, and community development. Her organizations also run community college affiliated with Indira Gandhi National Open University to equip youth with vocational and life skills. She's a leading voice in police and prison reform. She's recipient of the famous Ramon Magsaysay Award along with several national and international honors. She's written many books, such as It's Always Possible, What Went Wrong, As I See, Broom and Groom, Fearless Governance, and finally her autobiography, I Dare. She's on media as a commentator, columnist, and just by the way, she happens to have a master's degree in political science and PhD in social sciences from IIT Delhi. Welcome, Dr. Bedi. It's an honor to have you. So, when I first heard you've agreed to join us, I told Shanti that, hey, we need a whole session with her, not part of a panel, but you were gracious enough to say no, you will join. So what question am I gonna ask you? Why don't you just tell us how to fix the India's criminal system? If you can unmute, please. So how are we fixing India's criminal justice system, Dr. Bedi?
It is totally fixable, provided every arm of the criminal justice system wants it. It is the vested interest in every arm of the criminal justice system which is holding it back. And it is so disjointed that we are not listening to each other. We don't look at it as one system. We look at it all ourselves. Police looks at it its own selves. Lawyers look at it their own way. Courts look at it in their own way. Prisons looks at it in its own way. Legislatures look at it in their own way. The community looks at it in their own way. Nobody brings us together. Today, you have brought us together. Today, and this is something my friend Chuksab, I've been asking, please bring us together. I've been saying this for many years, that somebody needs to bring the criminal justice system stakeholders together. For what? To listen to each other and not accuse each other, but listen to each other and on a regular basis. And something I suggested was, so I think we can fix it. If we can come together and look at it listen to each other in an unbiased way and open-mindedness. And then each one organization doesn't say what you can do, is what we can do. I can do. So if I'm the police, I can write down what police can do to fix the system. The lawyers can decide what they can do to fix the system. The just courts identify what they can do with what they have to fix the system. Because I'm a believer in practicing with what I have. I don't want to wait. I want to begin with what I have. So when everybody begins with what they have, there will be solutions and solutions. And then we can come to systematic approach of what else that we can take from each other. So I would think my short answer immediately is it's fixable, provided each arm of the criminal justice system wants it, identifies and does self-reflection, and then says, I will fix this. The ball is in your court, but I will bring with my responsibility, not with my right. So I don't want to begin with my right as a police. I want to begin with responsibility as a police department to fix it. So it's fixable, provided we begin with this optimism and this approach and this attitude. It's fixable. Even within the existing resources and the laws and the system we have, we can begin and then we can move on.
Okay, so no blame, but taking responsibility. In your mind, who bears the greatest responsibility for India's criminal case backlog? The courts, the police, the prosecutors, the defense lawyers, the legislatures, the government, the litigants, who?
Tuksab is the leadership in every aspect. Leadership in police, leadership in the courts, leadership in the legislatures, leadership within the community leaders. Everybody has a role to play uniquely. So it's not one leader, leaders, but there is there's somebody who has to bring us together. Who could bring us together? It is the political leadership. Political leadership has to begin, like the law minister and the home minister play a wonderful role. If they combine to do these kind of conferences and listen to each other. So law ministry, why? Because it concerns laws and the courts and the police, and the home also police and the infrastructure. And I'm not bringing in the finance minister, because the home minister can ask for budgeting for infrastructure. So I would think I would begin with the political leadership of law and home.
So you've traveled around the world, and even in countries where there isn't a significant backlog, they do courts on weekends and they do courts at night. There was even a television show which was very popular called Night Court. And why doesn't India look at it as an emergency? And we have courts on evenings and weekends.
So that's a solution. It's an option. Will any vested interest allow this?
Isn't it good for everyone?
It is good for all. But now you're beginning with the courts. The courts could say, why not others? And why not this? So I think you're beginning with the courts, but we could begin. As I said, why not use the infrastructure twice over? It's like I'm telling a college sometimes when you go to speak to a college and they say, what do you do with this building after 3 p.m.? Why do you just let it be? Why can't you do skills at university? Skills after 3 p.m. for all the residents of the area and use the infrastructure doubly. So it's the way you begin. That's the point. And they're not willing. They say, no, where is the staff? First you want to do, then you can get the solutions.
So in your mind, with so many years of experience, what would you say, where is the biggest cause of the backlog? Is it the administrative? Is it the judges? Is it the litigants? Is it the lawyers? Who's causing the biggest delay?
It's a blockchain. So you can't say which one. It's a blockchain. Begins with the community. To my mind, it begins with crime prevention. Why are we not focusing on crime prevention so that we reduce the registration of the cases? So crime prevention. The role which the community leaders, parents, society plays. That's the society as a whole. And society is comprising of all these parents, teachers, community leaders, etc. So first, let's prevent crime from investigating and trying. So crime prevention begins with the community and the police, both. Crime prevention plans and the community work together. It's like crimes against women. You cannot just blame the law courts for pendency. Why is it allowed to happen again and again? That the role of the teachers and the education comes in, and the grooming. So I would say, you can't say begin. I would say you can begin from anywhere. You can begin from anywhere, but you can begin with crime prevention. And then comes the issue of pendency. What do we do with investigation? What do we do with the trial? What do we do with the reform? Again, so that he doesn't become a revolving door. What do we do with the community which reintegrates? What do we do with the rehabilitation as the community accepts it, and the skills development? See, prisons also comes in. We don't even talk about that. So I would say you can begin with loading the courts less. Government, why should it go and appeal for everything? Why should we not look at resolution and better governance? Better governance will reduce. Better banking will reduce when it comes to financial frauds. So I think you can begin from anywhere. But as I said, crime prevention. When you say crime prevention, then everybody's involved.
I know we asked you and you had time pressures, but you were gracious enough to join. So that's why I'm focusing on you first, and we'll let you go soon. But before I let you go, I want to ask each panelist if they have any questions of you. And before they ask you any question, I want to ask you my final question. You did, in your book, It's Possible, you did a great reform with the Tihar jail. Can you share with us what was the biggest problem at Tihar jail and what did you do to fix it?
The biggest problem was corruption. Corruption. And corruption breeds everything. Violence, drugs, smuggling, abuse of each other, dislodging. So denial of the legal rights which are legitimate of the prison, it was corruption. All I did was made it transparent. The whole functioning very transparent and whereby personal leadership. Now it began with the leader. So I used to walk the prisons every day, check, and I had a feedback box, a secret feedback box where a prisoner could write to me a letter in a locked box and they could write to me anything. And it was a trust relationship. So there was lack of trust because there was corruption. I brought in trust and transparency. Trust and transparency, not through technology, but through a feedback box, because there was no technology at that time, and there isn't still. And I didn't even have cameras at that time. So feedback box. Prisoners used to write to me letters. I knew exactly in which barrack who was doing what. And I now did not reveal. I kept it anonymous and responded to every morning when I was on my morning rounds. Not through technology, but through feedback trust and credibility. Corruption was minimized. And then anybody found breaching trust was dismissed from service. Terminated. Out. You're retired voluntarily. Out. Okay. I'm not dismissing you because you may take me to somewhere else. I'm retiring you because I have evidence. It was evidence-based retirement. See, corruption was the main thing. And thereafter, once that went away, with transparency and feedback system and personal leadership, reforms started to happen and solutions started to come.
Thank you. Wonderful work. All the other panelists, would you have a question?
Mr. Chok, can I ask one question to Dr.
Yes.
Kiti? And I would like to request her, in case she's willing to work more, why don't she go back to Tihar and try to fix it again, because it's in real bad shape back again. Because what Dr. Kiran Bedi had achieved at that point of time, because we used to visit jail and we used to see the difference in the jail conditions, and also what Dr. Bedi has rightly said, it had become quite transparent and corrupt free. But today, again, the system is so bad there. It's serious overcrowding. And we have extortion rackets which are running from Tihar. If we read the newspaper today in the morning, there's an encounter which happened in Haryana of the extortionists who have been killed, and their own colleagues are parked in Tihar. That is what is reported. So our request to Dr. Kiran Bedi, why don't you pick up this assignment once again and do the needful for the effective criminal justice system, ma'am?
It would need another life for that.
I think maybe
how many jails is she gonna visit, Mr. Pava? What is the rest of the country doing?
But Tihar is the biggest in the world.
Okay.
Yeah, so that is one place which requires immediate attention, in my view, being a criminal lawyer, because we deal with that place on daily basis. It really requires attention of the government.
Is corruption still the first issue, Mr. Pava, or is there something else now?
No, corruption, when you have an extortion racket running, means it is corrupt. When you have, when they seize cell phones on daily basis, how do you smuggle a cell phone in the jail authority or a jail, like Tihar? It always happens within, with the connivance of someone. So corruption is the main thing.
Okay, we have 4 minutes left of Dr. Bedi, Karuna, Ramandeep, Justice Ranka. Dheeraj, any questions?
Well, I have one question to Dr. Bedi. Dr. Bedi, I was just wondering that I can see that you had retired in 2007 from the police services, and thereafter you've been involved with so many activities, including running NGOs. Do you see that from 2007 to 26, with so much of technology being improved, is there something that we can do, or is there something that could have been done in these last 20 years to improve, like you said, the policing, where it starts from, and also improve the quality of the policemen serving from the constable onwards all the way up? Is there something that we could have done, or is there something we can do with the advancement of technology?
If you're focusing on technology, yes, technology for hotspots, technology for crime prevention, technology for identification of repeat offenders, also technology to coordinate coordinate the police systems of the country.
Correct.
If I'm arresting somebody for a traffic violation and he belongs to Bihar, I should know it right away who is the person before me. So that record keeping, fingerprinting, face recognition, so that it saves us time to identify who is the person before me. So technological use of identification, documentation, analysis, data entry, and identifying who's before me. Sometimes it doesn't get to be known till almost the courts arrive and you don't even know where it comes from. So I think we have not used technology holistically, comprehensively, whereas we can. So India can, if it does. Even prisons, as we need to know who in prison is living where. Has he been here before? Because he may have come with a different identity. So therefore, technology can be used in a very effective way and a very cost-effective way.
And to add to that, do you think that we still lack a continued legal education or a continued education for our police forces, which can also improve the quality of and efficiency of the police force?
Yes, taking them back to training and in the barracks is a lot of time. It's a lot of resource taken away from the field. So therefore, every leader says, I'm here to bear the fruits and not sow the seeds for which I'll never bear the fruit myself. So they don't send you for training. However, there can be technological ways of training on regular basis. So every police station can have a training 15 minutes linkage to a basic control room, to one major control room, 15 minutes of updation, a judgment of a Supreme Court, or a new provision of the law, 15 minutes of law education through combined control room driven by cameras, and a 15 minutes of legal education. We can, provided we want to use technology and whether we want to use this as a good practice. It can be done.
Wonderful. Thank you so much, Dr. Bedi, for giving us some
I want
precious
to ask
time.
one question.
Yes.
I want to ask one question from Ghaziabad. Yes. Can I ask?
Yes,
Can I
please.
ask question? Yes.
Yes, yes.
Yes. What happened in Meerut few days before? This can be avoided. Can proper training to IPS officers is insufficient? Thank you. Thank you.
Sudeep ji, all the things which went into reform of Tihar prison is very, very well qualified, written in book, It's Always Possible. And if you see I evolved a model called 3C model. It was collective, it was corrective, and it was community-based. Now, what went into community? What went to the factor of collective? Community-based? All this is documented. Do you know, we really, if you look at the book, It's Always Possible, Navneet ji, if this book had been coming through a Harvard University, it would have become a course around the world. But we came from an ordinary, simple Indian, a woman from Tihar jail. That remained as a document. Nobody's looked at it as an Indian contribution. But I got invited from American, British, Japanese, Asian prisons to come and speak about it. But nobody here from India offered this as a model. Tihar books remains a model. It's been translated into many languages, but the question is, have we recognized and respected what we could create? It's collective, and do you know, Chuksa, it is a zero-sum game. I use no money to do the reform. I only made it collective. I made it community-based. I invited the NGOs to come and contribute, the volunteers and the communities and the NGOs. And we worked through zero budget. Zero budget. And in the third year of my tenure, I was almost now introducing skill development inside the prison when I was now doing PPP models, which came in later, saying you come and set up industry inside a factory or a machine. I give you manpower and I give you the resources. You skill them and employ them after. But by the time I was about to launch this, I was asked to leave the prison.
Thank you so much. We will never forget all the work you've done. And in hindsight, we should have called our today's title, It's Always Possible. My promise to you, we will remind our audiences once every month or two, we will do a criminal law session and we will talk about your book in every session. We made a promise to you that we'll leave you alone at 11:30. We'll want to honor that. Thank you so much, and please come again.
Hello,
I'm
hello,
very
hello,
Yeah.
hello, hello.
Yeah. Thank you, everyone. I know there's questions, but we'll ask other panelists questions. We'll let Dr. Bedi go. Thank you so much.
thank you.
Thank you.
Really appreciate you joining us.
Thank you. Look forward to being with you again and again. Thank you.
Beautiful. Beautiful. Thank you. Asti had a question. Asti, you can ask a question to any of the other panelists. Before you ask Asti, we have a panelist that's joined us. Ms. Karuna Nandi, can you please introduce yourself?
Good morning. I'm so pleased that this has been convened because this is really something that is fundamental. Because there is such a backlog in the criminal justice system, what happens, I think, is that, when we are doing cases, for example, for victims, what happens is that we oppose bail that much more strongly because we know that the trial is going to take a long time. So there are a lot of workarounds that, in fact, clog up the justice system further. So this panel is incredibly important. I'm a senior advocate designated by the Supreme Court, and I look forward to bringing my experience to the table.
Thank you. Welcome. We have a question from Asim Harish. Where did he go? Yaram, you had a question? Yes, Yaram.
Yes, sir. Good morning, everyone. I'm very honored to be here in front of all of you. So, my question is, as Dr. Kiran Bedi ma'am has said, we need collective responsibility from every sector of the government to change the criminal backlog. But since the collective responsibility is very hard and time-taking, it takes everybody's involvement. How can we rapidly do it? And how can youth like me who are like very unsatisfied with how the pace of how the system is moving, how can we also contribute to the system?
Okay, who wants to answer that? Anybody? Yes, go ahead, please.
So, Yaram, you've really asked the question of the hour, which is what we are all here to discuss. I'm sure others will also bring their suggestions to the table, but I think the biggest problem is something that is solved in a manner that is not a hack. It's not AI. It's not cool. It's increasing the number of judges. It's increasing the number of police officers. And it is increasing the capacity of the criminal justice system. Now, if I wanted to reduce the backlog in the criminal justice system within, say, 30 days, what would I do? At the moment, life expectancy, people's health has improved, life expectancy has improved, and people's ability to work further has improved quite dramatically. So across the population in India. So I do think that bringing in, I disagree. There were a lot of very important things that Kiran Bedi said. A couple of things I'd like to highlight. One was that everyone should work together, and that system, that flow, right? She used the word blockchain, which I thought was quite interesting. Then has to be costed, and it has to be laid before the parliament, and we need a finance bill to cost all of this. Criminal justice is very rarely costed. When I was training judges and probation officers and across South Asia, one of the things that we trained them in, and government people, in fact, all together, 8 countries of South Asia, one of the things that we trained them in was the process in Brazil, the process in South Africa, the process, whenever you have a criminal justice reform, if there is a financial implication, which frequently there is, even if it's just for training, right? You make sure that there is a finance bill. Now, the uncool solution to increasing the capacity of the criminal justice system, I think, is bringing in not police officers, not retired IPS officers. That would be a big mistake, I think, but bringing in retired judges. Before we have an increase in the age of retirement. There's absolutely no reason, I think, that judges of the I think subordinate judiciary is wrong, but of the district judiciary, the districts and session judges, and indeed the High Court judges, should retire at, and Supreme Court even should retire between the ages of 60 and 65. Because now the reason I think that we see a lot of retired High Court judges practicing in the Supreme Court is because, and this is way more than ever used to happen before, is because the length of professional life has just increased dramatically, and quite rightly so. So we have a huge capacity that already exists. Where I disagree with Kiran Bedi is where she was saying that, look, these same judges should be working at night. And I don't think that's right. Because, an exhausted judge is going to make an exhausted judgment. So what,
But
increase.
couldn't we have separate judges that work in the evenings from 4
So
till
there, I
11
think
p.m.?
Mr. Chugh is, therein lies some of the solution, because building a building takes a longer time than bringing in greater capacity. But one thing I would like to say is that as we increase the capacity of the police, we must make sure that we don't just say kad kitna hai, chaudai kitni hai when we recruit. That it has to reflect the diversity of the population. We must recruit for those who will uphold constitutional values, and not just those who will reinforce the prejudices and the might is right that we have in society.
But
So
then, ma'am, everybody wants to appoint more judges.
So now making sure then that we have women, that we have, that quota is not complete in most states. In Maharashtra, it is complete. I think in Uttar Pradesh, it's complete. But in other states, it's not even the quota has not been filled. In cases of SC, STs, that quota is state specific and reflects the composition of the state. And even that in almost all states has not been filled. So reflecting that diversity of experience, I think, is fundamental. You were saying, Yanam.
Yes, ma'am. But then, as you
Okay.
said, the country
We'll
wants
we'll come back to you. I have
Yes.
a question of Mr. Pava. So, Mr. Pava, all of you, please know that we are on LinkedIn and Facebook and YouTube Live. So we're getting questions from other sources as well. So this is a question for you, Mr. Pava.
Yes,
Can you please explain the question is that they're kind of new to the criminal law world of India, and they're asking, can you explain to us in a few sentences the entire process? So the police arrest somebody, and then what happens?
Okay. Okay, the criminal justice system actually gets triggered on the road. For instance, if there's an accident which happens or an assault which happens on the road, and we have people, those who have witnessed that crime. So the process starts at that place when a complaint is filed by an informant or by a victim or by a complainant in the with the police station. And the moment the complaint is filed with the police, and if it is a cognizable offense, then of course the FIR is registered. If it is a non-cognizable offense, then there is another process. Once the FIR is registered, then an investigating officer is assigned who conducts an investigation, collects the material, try to identify who has committed the crime. And in case he identifies and he feels the accused has to be arrested, accused will be arrested and will be produced before the court within 24 hours of the arrest, and then the process of bail starts. And when the investigating agency concludes the investigation, they file a report in the court, either in the form of charge sheet or in the form of a closure report. And then the court examines that report. If it is a charge sheet, then the accused will face the trial. If it is a closure report, then of course the complainant's right, the informant's right, those rights come into play and they challenge the closure, and then the court applies its mind. And then in case court feels accused have to be summoned, accused are summoned, the trial starts, the evidence is brought before the court, accused is given an opportunity to respond, the trial is concluded, judgment is delivered. This is into
And the investigation of the entire matter, is that in the hands of the police or the prosecutor?
Well, the investigation primarily in India is in the hands of the investigating agency. They have to independently collect their material and file a report in the court. We have prosecution department, which is an independent prosecution department, unlike many other countries where prosecution department is linked with the investigating agency. Here, the prosecution department is independent. The prosecutor applied its mind, and prosecutor may disagree with the opinion of the investigating officer and can raise objections. But prosecutor cannot reject the investigation report. The prosecutor can also point flaws in the investigation and request the investigating agency to prepare the final report in a particular format. And when the prosecutor comes to the court, his role again becomes very independent. He's like an officer of the court. There are various judgments of Supreme Court which have highlighted what are the duties of the prosecutor. The prosecutor has to be so independent that if the accused who is represented in the court forgets a particular point or does not highlight a particular point which is in favor of the accused, it is the duty of the prosecutor to tell the court that this is a point or an argument or an evidence which is in favor of the accused, and then it should be highlighted. Although it doesn't happen in our country, because prosecutors always feel that they have to secure conviction. They are more conviction minded than justice oriented, which is a major problem which I also have in the court. And very, very often, because they all are our colleagues, some of them are quite young. So I always carry a couple of those judgments and try to, send it to them on WhatsApp or airdrop them while I'm sitting in the court. The moment the matter is over, it's our duty as a senior, member of the bar to tell them what their duties are. Some of them do appreciate. Some of them do come back and they start, discussion on their roles. And then they, of course, amend with the, passage of time. I have seen prosecutors growing and becoming independent and also conceding in the court, which doesn't happen very often. But their role, if you ask me, is a very independent role. And the objective is to find unvarnished truths in the matter and to secure justice for all the parties. That's the job of a prosecutor.
Thank you so much. So Judge Ranka, I know you're a very decent person. I've known you for many years and worked with your son. And I know my question is not fair, but I have to ask. For this question, I want you to be not a nice person and blame the entire delay in the criminal justice system, not on the courts. The courts are just fine. The judges are doing a great job, but the entire fault lies with the police, the prosecutors, the defense lawyers, the government, and the litigants. So what are they doing wrong? All of this group of other people.
Okay, fine. Thank you. I'd just like to begin with the fact that a country that can conduct national elections for nearly 1 billion voters every 5 years and on time cannot conduct a national mission for timely criminal justice if that mission is led by courts, governed by law, protected by due process, and measured by justice rather than disposal statistics. To begin with, as has been pointed out by Dr. Kiran Bedi ji, I also feel that all have to be in tandem to proceed with a case or a trial, because there is a police investigation, according to me, is the most required when they need to be trained, because every now and then we see that even the CBI courts or otherwise High Court or Supreme Court, they pass strictures against the police authorities, like they have been working as a novice or as a beginner, or they have many loopholes left in the process of collecting evidence or cross-examination the witnesses or otherwise. So that has to be taken care of. Not only the police authorities have to be trained in the manner appropriate for knowing the law, knowing where to control all the evidences, knowing where and how to collect the best possible evidence to build up their own case. And certainly, and also my suggestion is that the lower court judges, the beginning judges at the small level, of course, they are just entrants. Maybe earlier it was that even they pass out law exam and they are appointed judges in the lowest court. They've hardly had any training. They are fresh. So every 3 months, according to my view, they need to be having training, and training in the manner that for 2 months or 3 months, initially they need to sit behind the High Court judge, wherever they are in that state, 3 or 4 lower judiciary magistrates or ACJs and all. They sit behind the High Court judges, watch how the proceedings take place, how the lawyers argue, how the judges react, and that things may gradually they will improve their own working while when they are presiding over the courts. So this is what I feel that should be the prime concern of everyone, and of course lawyers are there to guide or to say in the manner appropriate, of course, for their own clients or otherwise, as to how the case could proceed in the manner best possible, so that everything is in a routine and fixed manner.
So, Justice Ranka, why are the judges so lenient on lawyers and parties asking for repeated adjournments? Why aren't the judges super tough?
That is what the lawyers have to, because what my feeling had also been, lawyers come prepared, judges come prepared. At least 15, 20, 25, 30 cases, they come prepared. They work hard in the night, early mornings. They come prepared to pose questions, pointed questions to the lawyers. But every morning we see half an hour is wasted by the lawyers requesting for adjournment of that case, the other side requesting for the other side. And then if the judge is strict, then the bar goes on strike. They feel that that is not good. These things are there, Mr. Chok, and lawyers as they are. I can't say that, but certainly they should do justice to the client or the litigant which has come to him. Cases toiling years together, not only criminal cases, but civil cases toiling years together. And you see in the courts, I have seen it, the pleadings may be 50 pages, but the adjournment orders are running into 100 pages. Double the pages of what pleadings are. So that has to be improved by the lawyers itself. Courts can't dictate or direct the lawyers that we can only request, yes, please argue, we are ready to hear you. If you are not
January
ready,
January 25th, Justice Ranka, I'm hired by a company to represent them, and they want to fire their lawyer. There's trial the next day. So it's routine. We go to court and ask for trial continuance, new lawyer. I go to this court in San Francisco morning at 9 a.m. and I said to the judge that I know there's trial today, but I was just hired yesterday. And behind the judge is 20 exhibit binders with hundreds of exhibits. It's a jury trial. And the judge says to me, no, I'm sorry. There's 90 people standing outside for the jury empanelment, and you just coming today. You don't know how much these lawyers have bothered me in the past, and I'm not giving you a continuation. I'm sorry. Do you want to call the old lawyers back? And I said, no, the old lawyers are gone. So he says, I'm sorry. And then he turns to the bailiff and he says, call the jury in. I don't have a pen. I don't have a paper. I haven't looked at the exhibits. I don't have the jurors' names. I don't have the voir dire questions. I have my cell phone. And that's it. So I told the judge that, and the judge says to me, you can use your cell phone, but I am starting the trial. So I did a jury trial without knowing anything. The judge refused. And there's nothing I could do. The trial was going to happen. And if I had said, no, I can't do it today, he was going to enter a judgment in favor of the other party. But, I guess we worried about the attorneys going on strike. So anyways, so Ahmed, Dheeraj, Ramandeep, question to the three of you. We need to do something drastic. There's 70 million pending cases in the country. A quarter of them are criminal. And the average time to go to trial is whatever, 8, 9, 10, 12, 14 years. Can any one of the three of you tell me something
Hello.
drastic that can be done to reduce the
Mr. Chuk,
backlog significantly?
Mr. Chuk, I'm sorry to interfere. Actually, I
Yeah.
have to go. I have a matter to argue
Okay.
about
You want to answer that? Give
uh,
us a drastic measure and then you can go.
drastic measure for
To cut the backlog.
cut the backlog. I think before I start the process of cutting the backlog, I must know how much backlog do I have. I feel we should get an audit done about the cases which are pending in the courts. Number one, at what stage they are pending. Number two, whether they are minor offenses or major offenses, and whether they are compoundable offenses, whether they are heinous offenses, which needs to be heard at the first instance. See, again, today's newspaper, Supreme Court is focusing on the heinous offenses. Supreme Court has passed the guidelines, I think, last week, and issued letters to all the chief justice of the country that you pick up all those cases where then an interim stay has been granted in heinous offenses. Now, heinous offenses maybe only say about 4 or 5%. If you see the statistics, our major cases are what? Check bouncing cases, traffic violations. We talk about millions of cases, but those are cases which can actually be disposed of at a marvelous speed if we have an adequate system in place. So let's not focus only on the heinous crime, focus on the entire backlog. And if we use AI, for instance, for traffic violation, you'll be surprised there are courts, even in Delhi, who spend at least 8 to 9 hours every day from morning 10 o'clock till about 5 o'clock in the evening. They only do traffic violations. So a judicial magistrate, at least, one in Patiala, there are 11 districts. So 11 magistrates are doing only traffic violation matters. Then we have a problem in Rouse Avenue Court, which is doing only with Prevention of Corruption Act cases. Those judges have 1 or 2 trials listed in one single day. They get free by 11 o'clock. If they get free by 11 o'clock, they have 5 to 6 hours of working. The normal work is not even been assigned to them. Why? Because the Honorable Supreme Court has passed some directions 10 years back that we need dedicated judges for these kind of cases. So we actually need to overhaul the system. And if we overhaul the system, you will see that this kind of problem can be solved. Now, the problem is also of domain expertise. We have judges on the criminal side roster who are not familiar with the system. He may be an expert in IPR or maybe an expert in civil law. So imagine a judge who is not familiar with criminal law is having a criminal side roster who has 100 cases a day. He could do only 25. So 75 cases which are not even attended from Monday to Friday. So 75 into 5 is 375 cases. 4 weeks means around 3,500 cases. So about 1,500. So one bench is adjourning 1,500 cases a week to any other date. So the postponement happens without the matter even being taken up. So domain expertise, I personally feel the roster should be given to the judges who are familiar with this law, because criminal justice is a completely different ballgame. You can't expect someone to understand how the investigation works and how the trial court functions. So it can be fixed, provided we follow a system, because everybody blames lack of judges, that we should have more number of judges. We have judges who can't even dispose of 100 cases a day. There are judges in Allahabad High Court who can dispose of 200 cases a day. We have judges in Delhi who can do only 20 cases a day. So either they lack training, or they lack domain knowledge of criminal law. So we have lot of advices to make, but fact of the matter is we will be able to dispose of these cases, because your topic is 20 million in 90 days. That is very provocative. You can't dispose of 20 million. Even if we dispose of 25-30%, we'll be achieving a lot. So I feel
Thank you, sir.
I feel overall we should sit down and we should try to formulate some kind of rules on the basis of which we can dispose of cases, particularly those who are unnecessarily, they are just lying in the court and are not being attended at all. They are about 60-70%.
Oh, okay. So that's
Mr.
doable in 90 days then.
Yes, we can,
Mr.
provided we are able to identify them. So we have to conduct an audit.
So,
Okay.
Mr. Pava, if I may just very quickly, I know you have to go. Very quickly, if I may just respond. There is an audit, and it may not be an audit probably, but there is a figure that we have in terms of. So this is in reply to a question in the Lok Sabha, and as of 31st December 2025, the number which has been given is approximately 5.39 crore cases which are pending across Supreme Court, High Court, and District Courts. Out of this, 4.76 crore pending cases as on December 35, with roughly 63.66 were pending at the High Court level, and about 92,000 odd cases were pending at the Supreme Court level, which means about 85% of the national backlog is actually pending at the District Court level, at the trial court level. So you see, and that's the beginning of your criminal justice system, right? District level. So if you have to eliminate the pendency, you have to start right from the bottom and then work upwards. So just to respond to the numbers that you were saying, there is some kind of a number. I don't know how correct these numbers are, but there's certainly some kind of numbers in the open domain.
Just one last comment. We don't use technology in the trial courts. There are trial courts in our country which don't have computers. They are still on typewriters. If you go deep inside Uttar Pradesh and Bihar and Odisha, they're still on typewriters. So they don't have access to technology. Now, I went to Greece to conduct a trial along with some Greek lawyers. And I have an instance where I've seen from my own eyes 20 witnesses being examined in one single day. And how do they examine it? They examine with technology. They don't have typewriters. They don't have computers. They record the deposition digitally. So the witness is called, witness comes to the court, witness has a mic, the judges have a mic, lawyers have a mic. They start recording the evidence. Cross-examination is happening just like we are talking now. Everything is recorded, and within, say, about half an hour, the evidence is concluded. What happens in our country? The witness comes to the court, he is given the oath, there is a typewriter, there is a computer operator who's writing his name, father's name, then the oath, then a question, then the answer, then the question is changed, answer is changed. One single witness in our country, even in a most efficient system like Rouse Avenue Court, takes about a month or maybe 15 days if he's an important witness. There, 20 witnesses were recorded in one single day. So therefore, there is a drastic, there's a requirement of drastic changes. Technology doesn't mean bringing only computers. Even in a place like Dubai in DIFC, the evidence is recorded just like we are talking, and then transcript is provided after some time. Because you can't prepare, you can't type. We have a judge in Delhi High Court today who does not use a stenographer. He wants a typist. So typist has to type even the order in front of him, and then he corrects the order. He could only do 10 cases a day. So these are the problems which we face, but of course they are all, we can achieve it. There's no doubt about the fact that I in fact agree with Dr. Kiran Bedi that it has to be a collective effort. It is not that you start blaming only the judges or the lawyers or an adjournment or the process of service of summons or warrants. These are also, every aspect of the matter has to be changed. and improved. That's my personal view on this.
Thank you. Thank you very much, sir.
Take your leave,
Please
and
go.
thank you so
Good
much.
luck.
Thank you
Good
so
luck on
much.
your
And
hearing.
thank you so much for calling me. It was a pleasure to be here. And we should actually have these kind of discussions, more often, because they are very productive and we learn about each other's point, and then we should
Hello.
come back to. Thank you
Come
so
back.
much.
Get your client
Hello.
acquitted. Yeah, Miss Nundi,
Hello.
you had your hand up. Thank you, Mr.
Karuna, you're on mute. We can't hear you.
Hello. Hello. Hello.
I prefer being referred to as Ms. Nandi in professional fora. So
Hello. Hello.
I think there's
Hello.
something to be muted.
Yeah, Shanti will mute them. Yeah, go ahead.
So here's the thing, that we do have the data, right? And this is the point of talking to each other. So we do have the data, not just the data on pendency, but we also have the data broken down by offense. It's not categorized into minor and major, but it's quite easily categorizable. Why? Because the National Judicial Data Grid, as well as the National Crime Records Bureau, classify cases by offense type, court, age of case, and and by criminal. So look, I think the thing is that some of the suggestions that have been made will be very helpful on the margin. Things like using AI instead of stenographers. So in the Supreme Court now, we do have, I know that one wants to put people out of a job. People can be retrained. But in the Supreme Court now, we have a sort of simultaneous appearance of what is being said, right? Which is really speech to text recognition is very, very basic technology now. So for something to come immediately and to be corrected immediately is something that's quite simple. We also do have the data. So now we have practitioners, somebody who's quite good, like Mr. Pava, and others who are similarly very competent, all of us here. And we don't always know, we only know one side of the elephant. So this is I'm glad you've got this conversation together, but it would be really great if on a regular basis we had the state having these conversations. That's far more important, If you had various ministries sitting down, if you had the Home Ministry, of course, which is the nodal ministry, sitting down together with the Finance Ministry, sitting down together with the Women and Child, Social Justice and Empowerment for Prevention, and all that are relevant, even urban development ministries, for example, right? In terms of prevention, so that we have lighting, so that we don't have abandoned streets. So when we think about hawkers, we don't just think about clean and safe and empty roads. We also think about a population, a place that is populated enough to prevent crime. That's just a very small example. And that when you're bringing in a criminal law amendment bill, and I was part of the 2013 anti-rape laws, then you are bringing really everyone together at the table and making sure that each arm, whether it's the police, whether it's the state departments, whether it's the prosecutors, are taking responsibility, and then having money put where their mouth is. And so that there are synergies and conflicts that are then resolved. I also, it's 12:10, and I've been very delighted to have listened to everybody and been here for an hour. But I also, I'm afraid, have another commitment to go, and I'm extremely appreciative of the occasion to be here.
But if you're leaving early, then you have to come join us for another session. Is that okay?
I would, absolute pleasure.
All right. Thank you so
Thank
much. So, Ame, if you look at the developed world,
Yes.
all over Europe, the big countries, the rich countries, the high per capita income countries, 40, 50, 60, 70% of criminal matters are adjudicated on plea bargaining. The prosecutor and the defense counsel and agree to whatever they agree to, but it's resolved and the judge signs off. In US, the number is 93, 94, 95%. In federal courts in US, that number is 99% of the criminal matters are handled in a plea bargaining. What's up with India? When are we going to resolve? Because half of the criminal matters I feel could be resolved on plea bargaining. What's going on?
So plea bargaining is absolutely underutilized in Indian courts. See, here plea bargaining is useful only when it is by choice and not a shortcut which is imposed on the vulnerable. Basically, plea bargaining is the most underutilized situation in India. Basically, where the accused says that yes, he is guilty of something, and he any compensation is to be paid, that can be paid, and the entire process of the trial is excluded. What happens here is maybe the victims or the accused are not guided properly, no independent advice is given, and pursuant to which they plea not guilty before the magistrate court. After which, what happens is that the trial continues. So, which could have been ended without this trial when a plea bargaining is accepted. This entire process of trial could have been, excluded, but that is not happening. Or I would say it is absolutely underutilized in Indian courts.
Who's at fault?
So maybe they are the accused are not appropriately advised, and not making them know about the procedure, or about what's the outcome and what is exactly plea bargaining. So that may be the fault.
Okay. So
Yeah,
Dheeraj and Raman.
I
Ramandeep,
want to
please go
point out
ahead.
over here. Sir, I mean, see, plea bargaining in US, as part of in countries like US, litigation is expensive, So people are aware of, where they would get litigated. But in India, litigation is expensive, but litigation is also very cheap. I mean, if you go to courts, you'll find lawyers. There are lawyers like Mr. Power who are like brilliant in their profession. And there are lawyers, if you go to district courts and completely static, they'll come up to you asking that, can I help you? So imagine if you get lawyers who are available for you, who'll convince you that they can do anything for you. So why would you go for plea bargain? Because lawyers also have to take responsibility to guide people, to guide the litigation, that this is the deal what we can get you, what we get you to this. But in India, the availability of lawyers is such that the concept of plea bargaining it is not there at all. In countries like US, other countries, litigation is very expensive. In India, litigation is expensive, but there are only a few section of lawyers to take out the property. There are very few lawyers which charge obnoxious amount of people are educated. But there are those other segments of lawyers also, who are available for each and everything. I mean, they'll be available in the night, in the day, every time is them. So hence the litigant feels that I can do anything what I want because my lawyer is convinced.
I don't know what you charge, but Amay charges $500 an hour, so I don't know who's paying him and what kind
Yeah,
of.
there are many lawyers. There are many lawyers. I mean, there are lawyers who charge 5 lakhs, and there's lawyers who will find it to charge 500. There are lawyers, but will charge 500 bucks. People this because they will. I mean, you see that they'll call you by the can I help? Can I help? That is also a problem over here.
Yeah. So we've been talking a lot, Dheeraj, and it's your turn now. Can you give me one or two or three practical problems and like tell us what's deep down dirty or bad? And the hardest things in life are the simplest things. So can you like turn on or off two, three switches to two, three simple delay issues that can make a big difference?
Yeah. So, it's interesting because we've heard Dr. Kiran Bedi, we heard Mr. Pava, heard Mr. Justice Ranka as well. And if I may just kind of try and summarize, in terms of what they've all said. So there are about 6 points that I'd like to make on this. First of all, we spoke about the pendency, we gave you the numbers. Now, there are two kinds of cases which we see. One is the contested criminal matters, the other is the clearable dockets. Now, when you talk about contested criminal matters, like Mr. Pava said, the Supreme Court is also looking at it. these are heinous crimes, etc., which require a lot of time. Possibly trying to bring them within the 90-day circuit is maybe not even justifiable, because it requires much more evidence to be led. It requires much more work to be seen at the witnesses, etc. So maybe 90 days is not a practical solution. But then there are others which are non-heinous. For example, 138 matters, which are check bouncing cases. For example, motor accident tribunal matters. Now, these are matters which can clearly be very, very swiftly concluded within 90 days. So please remember, that's the first part. Second, do we have the law? Do we have the statute? Yes, it is very much there. For example, plea bargaining is very much part of our statute. It is not that it is new in BNS. It used to exist even in IPC, right? So it is not as if statute is lacking in any form. What is lacking is the support, the execution, and the implementation. Now, third point, the paradox. The paradox is India is the world's most populous country. Yet, the irony of the situation is that we are struggling here for judges. Why is it? So, in fact, I would request Mr. Chuk, next time you have a panel like this, please invite somebody from the bureaucracy as well. Because what is important for us to know is that why is it that funds are not being allocated to this serious and critical and crucial system, which needs to be revamped completely? Because if you have funds, you can employ more judges. You have a huge educated capacity in India. Why is it that you can't have new judges? Why isn't that money can be put in create more infrastructure, buildings, technology? You heard Mr. Pava saying this. I can tell you, sir, I also practice as a civil commercial arbitration lawyer, and I can tell you this. 20 years back, when I did an arbitration in Singapore, there are transcription services then. In India, we have finally accepted transcription services in arbitrations, international commercial arbitrations held in India only in the last 3 to 4 years, which is when an Indian company decided to bring it into India at reduced cost. So why is it that we cannot have a full-fledged transcription services in trial courts where evidence can be recorded within 30 to 40 minutes, where you can actually have cases finished within 15 to 20 days? A trial can be finished if you have live transcription services. So that's the first point. And when I say about technology, when I say about infrastructure, bringing in money, please understand, we have something called an IPL in India. I know cricket is just becoming familiar in US, but we have an IPL in India. So do we know that the worth of IPL in India is 18.5 billion? It's entertainment, it's sports. When we can spend that kind of money on something like an IPL, why isn't that we can put in more funds into creating infrastructure and capability? So that was one of the things. I think and if I may just kind of give some solutions, because we talk about problems all the time. In fact, it just may give some solutions. 6 or 7 solutions that I can think of offhand. We have something called Lok Adalat, which happens only on Saturdays. If we were able to increase the Lok Adalats, which is basically conciliation and mediation in some form, where both parties go back happy and you conclude the case. But perhaps scaling up Lok Adalats is one. Revive plea bargaining and encourage plea bargaining. So when a matter comes before the judge, you actually keep the lawyers aside and ask the judge to ask the clients that, see, we can finish this matter if you do a plea bargaining. There's no harm to it. There's no stigma to it.
Have you
Most
ever done a
importantly,
plea bargaining in your life?
I'm so sorry.
Have you ever done a plea bargaining in your life with any of your clients in the
Frankly
last 25
speaking, what Amay said and what Raman said is absolutely correct. We do not encourage plea bargaining here because that's not been our culture. So we would rather go and fight for the client. We'll defend the client. We'll say, no, we'll finish it. Yes, in civil cases, we will often encourage people to settle the matter. Yes. We'll say, okay, you're not going to win this matter. Let's settle it. But in criminal cases, I don't see, also for the reason, sir, the prosecution comes very heavily on you. The prosecution is also not able to convince itself that a plea bargaining can work out in this case. So There is, of course, compoundable offenses within statutes. A lot of statutes provide for compoundable offenses. Even for compounding, we have to put a lot of pressure on the client to say, listen, let's compound it, let's get away, pay some money and get off with this. It happens in corporate cases. But that actually links up to my next solution, which is decriminalizing and compounding petty and technical offenses. Now, we have a bill which is being debated right now before the Joint Parliamentary Committee, which is decriminalizing the Companies Act. Now, if we do that, you will find a lot of cases insofar as corporate and criminal liability cases, the criminal liability of corporates going on by paying some kind of a hefty fee or some kind of a smaller fee. The fourth, the technology-driven factors. I asked this specific question to Dr. Kiran Bedi, is can there be technology can help us? Yes, of course, it can help us in crime prevention, crime detection, subsequently trials, and eventually everybody can benefit out of it. You have court, you can actually establish, if you have infrastructure, you have judges, you can literally start. And I can give you one example, and maybe people from Delhi will resonate with this. You go to Patiala House in the morning, and you will find that all the under trials are brought to the court. They are kept in one particular place, and then their cases are taken up in the afternoon. They sit there the whole day, and in the middle of this, the judge is handling 3-4 cases together. Right? On one hand, he's looking at what the trial is happening. One hand, he's also listening to arguments. He's doing 3 things. He's multitasking himself. Now, if you have judges and if you have infrastructure, these under trials can actually either be brought early in the morning from say 6 a.m. to 10 a.m. and those matters can be over. The judge can then focus between 10 to 4 into other things. Specialized courts, time effective courts, you can actually run these night courts from 6 in the morning to midnight if you have enough number of judges, if you have if you have this infrastructure to support that kind of thing. So I think these are things which can be done, and at the end of it, I would say yes, it can't be done without the stake of bureaucracy, politicians, judges, lawyers, everybody in it. It cannot be done by one person. It
So
has to be
Justice
a
Ranka, let's talk
yeah.
about bureaucracy. Thank you so much, Dheeraj. Justice Ranka, I'm surprised when I talk to lawyers in India, and one of my favorite questions to ask them is whatever state they're in or I'm in, I ask them that, hey, who's your state law minister? And 99% of the time, people look at me funny, like there is a state law minister. I know there's a federal law minister, union law minister. And I asked a lawyer who was born in Pune, lived in Mumbai all his life, 35-year-old. I said, do you know who Maharashtra's law minister is? He says, I didn't know Maharashtra had a law minister. And it was then the former chief minister who was the law minister. So, we talk about bureaucracy, and 1.4 billion people can't be run by one party, one person, or 2 people in New Delhi. And okay, there is a delay in the justice system. There's no plea bargaining in Uttar Pradesh, but maybe a state that's 100% literacy or whatever, maybe that state can fix its legal system. What is going on when we talk about bureaucracy? The states don't have any independence in fixing the legal system in their state?
As far as local laws are concerned, that can be governed. But majority of the litigation or cases revolve like all the central laws. So they are governed by that. So if the state laws are there, then certainly it can be disposed of in the manner according to the state laws governing that crime or otherwise. But majority of the laws relate to central laws. So it has to be governed by the legal system which is prevailing throughout all the states.
Can a judge be appointed in Chennai without New Delhi being involved, or no?
No. It has to be through the process of collegium and approval by the Chief Justice of India in concurrence with the every file goes to the Home Ministry, Law Ministry, and then ultimately President has to sign the warrant even for transfer.
So much for one day having 29 states having their own Supreme Court to hurry up and finish cases. Okay, so we have I have a bit of time left, so I'm going to focus on all the dozens of questions that are posted, and let's cover a lot of them. And so when I ask you a question, please give a real quick answer, short answer, so we can cover a lot of these questions. Okay.
Hello.
First
Hello.
question.
Hello.
Yeah.
Hello.
Yes.
Hello. Good afternoon, all of you. I am from West Bengal. I know there is a provision of fast track court to address the extremely case like rape and murder cases. My question is, what is the status of fast track court and its activity in West Bengal? Because there are many cases which is not been solved. So my question is, what is the how many numbers of cases are placed in fast track court in West Bengal, and what is the result, please? Thank you.
Who wants to answer?
I think according to me, only limited number of cases are given to the fast track court, and that appears basically heinous crimes and all, or other very serious offences cases. That is what I can say. Not all cases can go to fast track courts, and of course, government is also slow in appointing fast track courts and otherwise. As rightly pointed out by my other friends, infrastructure and according to the population, the judges ratio is too minimal. So it has to be increased to a large extent. And of course, what has been conveyed earlier also, age being 62 for the High Court judge or 65 for the Supreme Court judge is nothing these days. So it has to be gradually increased. If a politician does not retire even at 75, why the judge who gets experienced over the years should retire at 62 or 65?
Sure.
That
So
has to be
Ramandeep,
taken.
thank you, Justice Ramandeep, next question for you. What's the role of private ADR in mediation in criminal matters?
So I think in criminal matters, I don't know how ADR and mediation would be because the state is involved. In India, there's a trend. I mean, if anyone looks at a complaint, it's probably, I'm for the crime and someone from the state would look at a complaint, and we can make out if it is, if the case is actually worth it. But the state will always have the pressure, to indulge and defend the state, but the state would never cooperate. That is the threat. So same way in ADR, I mean, what we get is ADR from the criminal matters or mediation. That has never happened, and I think that never happen because there are not many things that need to be, the criminal aspect of the totally different aspect with the other matter. Because the investigation in criminal matters, investigation is very important. Every criminal matter starts. The investigation has to be fair and it has to be independent, and where the investigation is not fair, because investigation in India is run by bureaucrats, politicians. I mean, the interference by them is law. So from the inception of a criminal case, where there is no fairness because of the involvement of such entities, it's very difficult. Now, I don't know how much ADR would help in criminal matter. I doubt it.
Okay.
Good afternoon.
On
Good
the
afternoon,
point
sir.
of
I
ADR,
have a question.
sorry, on the point of ADR, is ADR absolutely not possible in criminal law? The answer would be no. Because as my seniors have also said earlier, that all these petty offenses which are compoundable, and for example, family disputes or any other small commercial disputes where settlement is possible, can always have a route through ADR. Not now, but maybe some reform may be possible in future, where all these cases where they do not have to go through this entire process of trial and can be disposed of in a much timely manner, can adopt this alternative dispute resolution like in civil cases. So that's the point.
Good
Okay.
afternoon, sir. I have a question. The question is that it is initially at the ground level, the pendency of the cases start. For example, a illiterate person or any other person goes to police station for registration of his complaint, but that the police officers brush away the complainant just not to involve in the all the complicated matters, and then they goes for private complaint in the courts. It is like there's no coordination of the police authorities and with the community, as Dr. Kiran Bedi said. So, what would be the solution to that? I mean, there's so much of pendency of private complaints just because the police officers are not cooperating with the community or the local people.
Dheeraj, you have an answer?
I don't think there is a as I said earlier also, the law is very clear, the process is very clear. Now, when a person goes to file a private complaint, and if the police, what's the stage? The police has to first investigate it. They have to look into the complaint, they have to inquire into the complaint, and eventually at the end of the day, if the police comes to the conclusion that there is no criminality in the offense, or for that matter, this is not an offense which needs to be registered, then the police will give a report. Now,
But
eventually
that
after that,
I'm sorry, but there is so much of corruption at the ground level. Like the other side, for example, pays what his dues are towards the police officers. They will not investigate the matter.
which is exactly why you have the process from where you can approach the court under 156(3), and then you have a judicial officer sitting there to look at that complaint, and then if the judicial officer is convinced that there is a case to be investigated, he directs the police then to investigate, and then the police has to file a report as to say whether this case, according to them, why it should not be registered as an FIR or not. Now, also remember that even if the police files a negative report to say there is no criminality, you still have an option of filing a protest petition at that point of time and saying that no, the police has done a wrong job and this is the reason why a criminal case has to be registered, and then the judge looks at it. So there is a element of check and balance which is already provided in the statute. Now, if the root cause is corruption, that's a separate topic which we can go and speak for hours on it. But as I said, we have a process in place, we have the law in place. It needs to be just examined and effectively implemented. That's all.
Okay, last question. Ayaz, go ahead.
I'm
Hello.
Dr. Ajit Sma. I'm inspector with Delhi Police, and I'm looking after the transportation and production of under-trial prisoners to various courts to begin with. Someone suggested that there should be a provision where
Hello.
under-trial prisoners.
Yeah.
Hello. Good afternoon.
Can you wait? We have a question pending. Yeah, go ahead, Ayaz. Did you finish?
Yeah, good afternoon,
Sir,
sir.
no.
Okay.
My question or suggestion is, we have been for so long have been requesting judiciary to at least make a provision wherein the under trial prisoners who are brought to courts just for the extension of their judicial custody or for rehnumai be produced through VC at least, which constitute almost 70 to 80% of the total production that we undertake on a particular day. And for the reasons best known to judiciary, our request is not acceded to. Had this been implemented, it would have taken a major chunk of pressure on the judges, and they can focus more on the matters that matters most, that is trial of the cases, which is not happening. So
Okay,
would you like to comment on
let's ask
this?
Justice Ranka to answer.
I think that's a good, very valid suggestion, and certainly it has to be implemented by the statutes. Certainly, and of course, the judge can begin with the holding e-courts or virtual courts by granting permission for extension or otherwise. There's nothing wrong in that, because bringing under trials to court 70, 80, waste of money, waste of petrol, waste of energy, time, money, etc. Everything is there. That should be a prime question for the just to
Model.
decide
Right.
and make it more convenient so that
Okay.
rightly said he can devote more time for the effective working of other cases.
So
We
some
want
of
to
the
keep
courts in
our, we
Mumbai,
want to,
some of the courts
yeah,
in Mumbai have already started this VC procedure
okay.
for bringing under trials.
Okay. Thank you so much, Ramandeep. Thank you so much, Amay. Thank you, Dheeraj. Thank you, Justice Ranka. We want to end at our promised time. Astha and Yaram and Kundan and Krishnamurthy, I know your hands are up. Thank you so much for caring about law in India. Please come back. You will get first preference for questions next time. Thank you, everyone.
Thank
God
you.
bless you all.
Thank
Sir,
you.
Thank
I
you,
have
thank you.
last question. Sir, one last question I have. A very small
Okay,
question actually, if you don't mind. Sorry
sure.
to hold in on. Sir, I want to ask from Justice, Honorable Justice Raka, sir. Sir, we have talked about ADR and plea bargaining, but we also know that most of our clients don't really satisfy with this system. Along with that, due to this, the young first generation advocate are mostly exploited a lot in our system. As me being an intern right now in final year of my law college, I have never got a satisfied paid internship, and even the internship are they interns are made to work 12 hours in a day, and they are not even paid. They are not even given the recognition properly. To Supreme Court should have work on it a little bit for the intern, especially for a first generation advocate.
I have a
So far
suggestion
as
for you. Please
in
dedicate your life to becoming the Prime Minister of India in the future. Get up every morning, look in the mirror, and say, I'm going to be Prime Minister of India in this lifetime. Every single person you meet for the rest of your life, tell them, I'm running to become Prime Minister of India and help me. Carry a card, make a business card that says, Future Prime Minister of India. Okay? Please don't give up. We need people like you. Thank you so much. God bless you.
Thank you, sir.
thank you.
Thank you.